All right, pause right here. This is a probation revocation hearing, not a trial. That matters. When you violate probation, the court doesn't need to prove guilt again. The only question is, did you follow the rules? And from what probation just laid out, this defendant didn't just miss the memo. She skipped the entire book.
Unsuccessfully.
Okay, so it looks like she did not submit to 26 UAs.
Correct.
She didn't get her treatment done. And she missed probation appointments. And she didn't report to sober living. Okay? And so you just want me to close it out with no?
With jail.
With jail.
Yes.
Okay. All right.
And we have an agreement with the DA to revoke and close this unsuccessful with 60 days jail, and that's what Ms. Chavez would like to do today.
60 days with all of that. And this is the first?
I believe it is.
She's looking at up to 364 days of jail. She did not stay in communication with probation. She didn't do UAs, which tells me she probably was under the influence. She didn't do any treatment. I mean, honestly, it usually takes at least 10 months to do the treatment that she was, actually more than 10 months. And she got level 2 and 86, which makes me think that this was not a first DUI.
This was a 2022 case, so this one's been going on for a while.
So the 22 case, we're now in 3 years later. And we're gonna give her 60 days when she had essentially almost 3 years to get this done. I would commit a DUI if I could only get 60 days and I didn't do anything. And I didn't do no UAs and I did nothing. And then I didn't go to super, I did nothing. And potentially was drinking and having a good time for 3 years.
But one good thing, she did complete her community service. She did that back.
She did community service. She had level 2 and 86. Community service was only 48 hours. You do community service in 48 hours through sleep. She didn't show up to probation, which is the easiest thing in the world to do. She didn't go to social living. She didn't do any treatment, and she didn't show up for a UA. And she gets 60 days? No, thank you. I'm not taking that. I do think jail is appropriate, but 60 days is not enough. Go back to the drawing table. Don't ask me about it. You can leave it open to me, or you come up with something better than 60 days. But when you do all of that.
This is where judges start doing math out loud. And trust me, that's never good for the defendant. 3 years of chances, 0 accountability. And now the court is being asked for mercy? Judges don't like feeling played. Question for you guys. Is 60 days fair here? Or does this scream consequences overdue? Drop it in the comments.
Oh, no. Yeah. Next, in custody. Have we figured something out?
Yes, Your Honor, I've spoken with Ms. Graham and Ms. Chavez, and we've come to an agreement to revoke and close unsuccessful with 300 days jail.
With who?
300 days.
That works. The court is accepting your admission to your violation of probation. Court is closing out your case unsuccessfully with 300 days of jail. Good luck to you.
Fuck around on probation. Find out there's jail time in your future. Now, I don't want to make this judge out to be a total hard ass, because while
and
she
just
does
like
hold
that,
people
boom,
standing before
negotiations
her accountable,
resumed,
she actually shows
reality set
compassion
in, and
fairness
suddenly
for
60
everyone.
days magically turns into 300 days. This is a perfect example of why lowballing a judge can backfire hard. Pro tip: when a judge says go back to the drawing board, they are not asking for crayons.
Yes, because it gets in your career. You sure you don't want to get representation?
Yeah, I get representation. That's right.
Okay, because I'm looking at you, and the reason I'm saying this to you, sir, is because my father was an officer in the military, and he was over a lot of airmen, and things like this can get you in your military career if it goes the wrong way for you. So I think you should probably apply to the public defender's office at the very least and find out if you qualify. Okay, why did they do this case too? 25F5162. I gotta understand why the division didn't handle all of her DD cases and wrap them all in deferred.
Your Honor, it's because they moved the case from the district court to here.
That makes zero sense to me, because Division One should have handled all of her DV cases. All of those cases that she got the deferred sentence on were DV cases, probably involving the same victim. So it makes zero sense that she had a public defender, probably in felony court, that didn't get this case wrapped in with the other cases. That makes zero sense to me.
I'm not sure if she pled guilty.
She did plead guilty.
I don't know if it's a deferred sentence or not.
Yeah,
So that's what I don't understand. Like, to me, it makes zero sense that she pled guilty on 3 DV cases literally this week, and they didn't take care of the last one.
I agree. And the notes say that we're on notice to address bond today in this case, in county court. I don't know.
This just doesn't make any, and is it the same victim on all 3 cases?
Yes, Your Honor.
That's incompetence.
I'll talk to the DA in that division.
That's absolute incompetence on both sides. Ms. Woolman got screwed over.
We agree.
This is my branch.
They told me.
But if they're going to give you and plead you on all your cases, but at least one, and then have me handle it, that makes zero sense. But they're willing to give you the first on those, then I don't know why they didn't just wrap this one in there too.
I don't believe it was a deferred sentence. I'm looking at the plea agreement right now.
This moment right here is rare. The judge is openly calling out procedural failure on both sides, prosecution and defense. Translation: the system dropped the ball, and the defendant almost paid the price for it. This is what judicial fairness actually looks like when it's done right.
Don't like is that you're driving. It is clear to me, and it should be crystal clear to you, that you don't have driver's license. You take a bus, an Uber, or get a ride. But if you get another case, understand. Yeah. You will stay with us for a long time. Okay? I will find you be, don't talk. I'm talking. I will find you be in direct contempt of a court order. And I will bring you in on contempt charges. And you will say, you, Mrs. Walker, Ms. Walker, you have to control yourself. Okay? You cannot have these outbursts that you're having. I'm trying very much not to pay attention to you because I fear that if I pay attention to you, that I will draw attention to you that I don't want to draw. Okay? The jury is watching. You need to control yourself. Okay? If you cannot control yourself, Miss, I understand, Ms. Walker, I understand. Ms. Walker, I understand. Listen, Ms. Walker, I understand that this is highly emotional for you and there's a lot of emotions going on with you. But I am requiring for you to control yourself. If you cannot control yourself, then I will have to use other means. And I do not want to use those means to control you, okay? So you're gonna have to control yourself. All right. So a couple of things I want to talk to you about before you take a lunch break. Before you go on a lunch break, it probably will be good for you to have a little lunch. Everybody have a seat. Let's have then arguments.
Yes, Your Honor. The people would be asking for the defendant to be remanded today for 60 days. Then we'd ask for 1 year of supervised probation with a mental health evaluation and substance abuse evaluation. We'd ask for the defendant to comply with the recommendations from both evaluations. The defendant's behavior since the verdict over the last 15 minutes has been very concerning to the people. The defendant, I heard her say she said, fuck, shit, goddamn, 1,000 times, not 1,000 times, but probably close to 100 times. She was yelling in the hallway. I asked counsel if they needed assistance with the deputy to help keep her under control. They said they didn't. She called the victim a bitch. She said, fuck that bitch. She also said, thank God my mom isn't here because I would have killed that bitch. The defendant's disrespect for this court and lack of remorse is concerning for the people. The victim is concerned for her own safety after this verdict. And so we'd also ask for a no contact order between the victim and the defendant. We are very concerned for the victim's safety and for the safety of this family.
Okay. And then what's her criminal?
A controlled substance F4, and I think she has a couple of misdemeanor convictions within the state. I can pull them up real quick, but I looked at them earlier today.
All right.
She has several charges for.
Let's be crystal clear. This is the warning before the warning. The judge is protecting the jury, the record, and frankly, the defendant from herself. Once behavior starts affecting the jury, the court's patience hits zero fast. At this point, the defendant is standing on the edge of a legal cliff.
Help and to stay away from me and from my home and from my children, including my niece who's been living with me for 3 years.
Okay, and how old is your niece?
She's 19.
She's 19.
Well, she'll be 19.
She'll be 19.
Yes.
Okay.
Yes.
And in terms of what you know about your sister, when you say she needs help, does she have like some mental?
I think it's undiagnosed, honestly. When she's not in this state of mind, she's like the sleeps person, but then anything sets her off, and it's a nonstop situation of calls, voicemail, text messages, not only to me, but to her own daughter, degrading, disrespect, driving her lives, disrespecting, threatening our lives, threatening my children's lives who are 8, 7, and 2. I work from home, and my husband's really scared to even leave because then it's like, how am I supposed to protect when I'm not there? So
what kind of piece of shit do you have to be to put your family in a position to be scared to leave their own home in fear of what might violently happen to their children?
Okay.
Well, that's what we're at.
All right. I appreciate it. Thank you. Mrs. Jacobs, your argument? Mrs. Walker, I'll give you a chance to talk when I get there.
Okay, we'll get there. So Ms. Walker's been working at In-N-Out for about a year and also works at the Hilton. So she's working 2 jobs right now. She's been doing the Hilton for a couple of months. And she's still experiencing homelessness, but she's been trying really hard to get back on her feet. In-N-Out is willing to transfer her and help pay for moving expenses. So she's been hoping to keep up working both jobs for a while, and she's been saving. Because she does want to move away from this area and move away from the troubles she feels she's been experiencing with her family. It's my understanding that In-N-Out gave her the okay to move anytime, but she's been staying because she's been wanting to get this case resolved. So she's really hoping to get out of the area to be able to get her life on track, away from her family, and kind of start over. And jail would set her back in that progress that she's been making. I also believe jail is not warranted. I understand the jury found her guilty, but at the end of the day, this case was about a voicemail. She's not charged with and not convicted of a violent crime. And it seemed to have arisen from an argument over her daughter's care, who is now 18 years old and a legal adult. So I believe conflict over her daughter's care is unlikely to repeat itself since she's legally able to care for herself. I did not hear her say anything, any kind of threats about killing her mom, and I was sitting there in the hallway with her. So I don't know if she misheard it, but I don't think all of that was accurate.
Okay.
We are asking for a year of unsupervised probation with the mental health evaluation and treatment, which was the last offer on this case. And I believe based on our investigators' conversations with Ms. Taylor and with Ms. Walker's mom, and based on what Ms. Taylor said, I think help is really what her family was hoping for. So I think mental health is more appropriate. I believe asking for jail at this time after we went to trial is something of a trial tax in this situation. And so we are asking for just the probationary period and the mental health evaluation.
Yes, Your Honor. I just pulled up the defendant's record. She has 2 guilty pleas and violation of protection order in 2 different cases. They were felony cases, but they were reduced down to violation of protection order. She also has a guilty plea to an M1 menacing, and that's what I could find. I also heard the defendant say in the hallway that if she gets supervised probation, that she's leaving the state.
Well, that's a good reason not to give her probation. And I don't know what she was thinking, but just because you leave the state does not mean that a warrant will not be issued, nor does it mean that the other state won't pick you up and send you back.
All right. Mrs. Walker, anything you'd like to say?
I just think it's a bunch of BS because I called DHS and they were the ones who told me to keep calling until you go home and your daughter. I just got into a car accident September 1st. I found out that my Medicaid was out. So I needed my daughter's birth certificate, social security card, which my mom should not have had in the first place. I only gave it to my daughter so that she could get a job. That is the reason why I was calling. I was not calling for any other issue. Not that I had a problem with her. I was specifically calling for my daughter's birth certificate and social security card. My family has been taunting me with my child for years. And they are doing that so that I can't spend time with my child. So they keep putting me in a worse situation. I just got a car. That's why my sister's here.
And this is where
Because in
everything collapses.
February, she
The
texted
judge
me-
tried to be flexible. Weekend jail,
In May-
job protection alternatives. But courtroom interruptions are the fastest way to turn compassion into contempt. One sentence could have changed everything. Silence. Instead, she talked herself straight into custody. Hard lesson.